Next is the Washington State Association of Counties, Derek Young, Interim Executive Director.
Good morning, Chief Justice, Associate Justices. My name is Derek Young. I am the Interim Executive Director for the Washington State Association of Counties, representing every elected commissioner, council member, and executive across the state and county government. Thank you for giving us the opportunity to speak to you about the proposed public defense caseload standards. In Washington's Constitution, counties are created as subdivisions of state government designed in part to carry out the state's duties at the local level. The criminal justice system is just one example. As you know, depending on the location of a crime and contractual relationships with municipalities, counties have jurisdiction over misdemeanors but handle all felony cases. Today you will hear from my colleagues at the Association of Washington Cities about our concerns about the impact of the new caseload standards on the misdemeanor system. I want to be clear that we agree. However, in the interest of time, I will allow for them to elaborate and focus on the felony system. Over the last few decades, the Legislature, Office of Public Defense, and the Supreme Court have found that the public defense system is in crisis. This is primarily due to funding. In Washington, the financial burden for the criminal justice system is almost entirely borne at the local level. The state pays just half the cost of an elected prosecutor, half the cost of each Superior Court judge, and about 3% of the public defense costs. That's despite the fact that the state retains responsibility for protecting civil rights under the U.S. Constitution. Among those is the Sixth Amendment's guarantee for the accused in all criminal prosecutions the assistance of counsel for their defense. Washington is very unusual among the 50 states in this arrangement. Nearly half pay the total cost of public defense, and another 10 pay at least 50% of the cost. Washington is near the bottom. In 2012, the Washington State Supreme Court established new caseload limits for public defense attorneys that were intended to allow for a lawyer to give their clients more time and effort necessary to ensure effective representation. Since then, county public defense costs have increased exponentially from $110 million in 2012 to $200 million in 2022. Meanwhile, state funding has remained essentially the same, rising from $5.6 million in 2012 to $5.8 million in 2022, an accumulated growth rate of only 3.6%. Current state funding for public defense falls woefully short of what's needed to meet our constitutional requirements across all counties, let alone the standards and limits recommended by the Washington State Bar Association. We understand the need and desire to decrease attorney caseloads and increase support for staff attorneys. Yet, without significant court or legislative assistance, it is unclear how any county can implement the new standards. If adopted and implemented, these standards will, at minimum, double or triple county costs without increased funding for these services. I want to be clear. Shouldering this burden, even without the proposed 3-year phase-in, is impossible under the current funding structure for counties. There's good reason to fund various services at the local level when they are largely for the benefit of local residents. However, this is not an appropriate way to guarantee basic constitutional rights across our state, as this court has found, for example, in the McCleary decision for public schools. Counties are required by law to balance their budgets. This encompasses expenditures associated with the civil and criminal justice system, including trial, court, and public defense costs. Counties must also provide funding for other constitutional and statutory responsibilities, such as administering the state's property tax assessment and collection system, elections, public health, emergency management, and growth management planning. Only the legislature can authorize the fees and taxes that counties may impose. The state of Washington limits a county's ability to raise revenue through property and other taxes. The legislature has neither provided adequate state funding nor authorized a dedicated funding source for counties to pay for public defense services. As a result, counties rely primarily on unrestricted local taxes, including or to pay for such services. A county's primary unrestricted local tax revenue is the general property tax. However, the legislature has imposed a 1% cap on general property tax. Because of this, the annual property tax collection grows at a rate significantly lower than the annual increase in costs for providing critical county services such as public defense. Furthermore, many county revenue sources are statutorily restricted to certain purposes that do not include public defense. These include county roads, affordable housing, and emergency medical services levies. Over the past 3 decades, multiple bills have been introduced to the legislature that would require the state to partially or fully fund trial court public defense. To date, the legislature has failed to act, leaving counties to shoulder this financial burden without any stable, dependable, or regular revenue sources. We are also concerned that this level of investment will crowd out all other important efforts to reduce the incidence of crime. In our view, the best way to reduce caseloads is to reduce cases, which means investing in crime prevention, social services, housing, reentry programs, and rehabilitation. The availability of attorneys is also a reality we cannot ignore. Even now, counties struggle to fill open deputy prosecutor and public defender positions. We are already beginning to see the nightmare scenario where suspects of violent crimes are released because public defenders can't be found for timely charging. Ironically, we believe the adoption of these proposed standards may actually make the situation worse. We've heard from contract attorneys who have said they won't be able to afford to take on public defense cases if these limitations on their practices are imposed. The study itself has some elements that we find problematic. It's based on analysis of 17 states, which did not include Washington. That's important because the standards and procedures adopted by this court are not the same as those in other states and could affect the demand for public defense services. Even within Washington, we hear from contract public defenders that procedures from county to county dramatically alter the time they spend per case. In fact, I came away from some of our discussions believing that the analysis of model courtroom management would probably yield some benefit. I'll allow my colleagues at the Washington Prosecuting Attorneys Association to cover our other concerns with the study and add that the budget repercussions of these recommendations demand that we get this right. It's too important. We have 5 requests for the court. First, reject the recommendation. We are struggling to meet current standards as it is. Adopting new ones without basis in reality will likely do more damage to the system than good. 2, go back to the drawing board. We recognize the crisis that we've heard from our public attorneys, both on the prosecutor side and the public defender side. Order an analysis specific to Washington, considering our current caseload standards and local rules and procedures. It should also consider the impact of implementation on the rest of the system. 3, if you adopt any standards, please lengthen the timeline for phasing so it has some basis in reality. 3 years will not work. We cannot be expected to meet these requirements if there aren't enough attorneys available for hire. Or better yet, adopt guidelines that we can make progress toward, but allow for flexibility on implementation that makes allowance for local conditions. 4,
on 3, what timeline would work?
we don't have a defined timeline and would need some additional time to work on that, but certainly longer than the 3 years. 4, consider moving up the non-attorney portion of the recommendation for legal assistance and social workers. We think this could have more immediate impact on public defenders' capacity and meaningfully contribute to positive outcomes. And 5, assign responsibility where it belongs, with the state. We cannot continue to allow the state to delegate so much of its constitutional obligation and expect counties with wildly different resources to meet statewide standards. I want to close just because we've been able to hear from some of our public defenders already and say that we certainly appreciate their hard work and understand the difficulty of their jobs. Trying to implement this from the budget standpoint is what we're here to do on behalf of our association, but we would not dare to tell them how to do their jobs and undermine the fact that both on the prosecutor side and defender side, these are dedicated public servants that we appreciate for the work they do. With that,
Can I ask you a question about
please.
Your association's legislative goals for the coming long session, and whether it includes a budget ask to help support these efforts?
It would actually not be a budget ask. We're introducing
budget authority ask, I
Yes,
guess.
yeah. We're introducing a bill that would require 50% of current standard funding from the state, so that's at the current standards, 100% for any additional caseload standard costs, as well as, and I want to make clear about this, we think some accountability and oversight should come with that. And that also means working with the Office of Public Defense, which does not currently have oversight over the system, giving them this new role, asking them to develop some standards, and then finally having local governments create plans for implementation. And so we can be held accountable to those plans. So we understand that new funding will come with some accountability, but we also think that that's a good way to improve the system.
So have you monitored the progression of state funding that flows through OPD and is allotted pursuant to contracts with specific grant requestors, I think in the city and counties as a general proposition? The question is, has that increased over time?
Yeah,
and do you know?
I mentioned that earlier in my testimony, and that's what I was a reference to. It's remained virtually flat the entire time. It accounts for about 3% of our costs now, as inflation has eroded that. When I started in my role as county council member back in 2014, it was about 6 or 7%. So it's eroded over time. The system works as a grant for cities, which you may hear about later. They regularly only get about 30 cities or so applying for it because it's inconsistent. We get a formulaic grant for counties, and so it's consistent, but it's very small, and it's just based on population, not on caseloads.
Can I ask another budget-related question? Because we hear often from folks in the legislature that counties aren't maximizing the authority they have, the tax authority they have. What's your response to that?
There may be, in some cases, taxing authority that hasn't been used. Most times, that is taxing authority that would not be permitted to be used for public defense. So it's for a specific purpose, like housing or behavioral health, something along those lines. Most of our counties are pretty close to their limits on property tax, which makes up the vast majority of general fund revenue, which is where you really need to look. If you're looking at smaller, increments, it's really a rounding error compared to the amount of need we're talking about here. And then you also have the reality that not every county has the same taxing capacity. Keep in mind that, King County is one example with a large commercial base and can raise a significant amount of revenue with that. But even then, a lot of the revenue just comes from outside in the unincorporated area, not in the city. We also have counties that are largely agricultural, which greatly limits their property tax capacity. So even if they were to increase to their cap, it might amount to $16,000 in some cases. We have a wide range of counties, and I think that's one reason that we need to consider that difference between Washington, say, Rhode Island, which is about the size of a county, but also doesn't have them because it's so small, the state can cover that whole system. We have parts of Washington where the entire county is the size of a small town in terms of population. And so asking them, for example, to designate one person as the Office of Public Defense for that county is unrealistic. So we need to think about some of these local conditions. Perhaps we create some circuits, for example, to try to assist those smaller areas. And the standards might be different for our urban counties, for example. I come from an urban county in Pierce, and certainly we've had our struggles. And also, one of those reasons is our tax capacity is not matched by our caseload demands, given the number of felony charges within the county.
I wondered about that point, the caseload numbers.
Mm-hmm.
I mean, we're talking right now of supporting the system as it currently exists, and trying to meet the needs of the system as it currently exists. Is there room for discussion about the number of cases being filed in the court system as opposed to perhaps alternatives to using the criminal justice system to address problems in our communities?
Certainly, and that was why I addressed one of our fears is, for example, the impact that this would have to our therapeutic courts or for alternatives to justice-involved responses altogether. Treatment, for example, trying to make sure that we're investing in the things that actually prevent the crime from ever happening, I think are good investments for our resources. But ultimately, and when something does happen, the charging decision is made by, at least for counties, our independently elected prosecutors and our independently elected sheriffs. That's the way our Constitution works currently. And the budget authority for the counties does not really have much control over those decisions. And then finally, I'll just add that, I think this is, based on some of the reading that I did through this study, and I must note, since I'm in front of the court here, I'm a non-attorney spokesperson, so I'm no expert on the matter. But when you look at what really demands a significant amount of time, it's those really complicated cases. And I certainly understand that we should be allowing for more time with those. But it seems that study seems to indicate an inordinate amount of cases going to trial, for example. And for my money, that seems like one of the drivers of this that seems unrealistic. So I would say we would be all in favor of trying to move more cases out of the criminal justice system, or just to be clear, trying to prevent those cases from happening in the first place. You know, I think it's very realistic to say that we should reduce victimization in our state, and then that would be one way that we avoid so many cases in the system.
Thank you very much for your willingness to take on the questions as well. We appreciate your input today.
Thank you all.